Have you ever had that moment where one answer hits you so hard that it's like your brain unlocks a hidden level? Suddenly, every conversation you've ever had, like every history lesson, like every random fact, every that doesn't make sense moment starts clicking into place. It's like those movie scenes where the genius stares into space, equations start flying everywhere, and the music swells as everything finally connects. Except in real life, nobody sees the equations. They just see you standing there, staring at the wall, looking like you've completely zoned out. Meanwhile, inside your head, your brain is putting together a 10,000-piece puzzle in about 15 seconds. And when it's over, you don't feel like you've learned something new. You feel like you've uncovered something that was hiding in plain sight the whole time. Because sometimes one question doesn't just give you an answer, it changes the way you see everything. I have one of those questions for you now. What if one Supreme Court case changed the course of American constitutional history forever, and almost nobody even knows its name? In 1873, the Supreme Court ruled on the slaughterhouse cases. In that case, Justice Samuel Miller wrote something that most Americans have never read. Justice Miller made a point to clarify the slaughterhouse rulings, of which forever interpreted the 14th Amendment into two separate classes of citizens. One classification for the American state citizens, of whom retained all his constitutional rights, and a separate and distinct classification for the federal United States citizens, of which would be governed under the 14th Amendment. The 14th Amendment provided privileges and immunities, but not all constitutional rights. In his quote from the case, Justice Miller highlighted the consequences of the slaughterhouse rulings. His concern was it made the 14th Amendment into a separate classification intended only for the freed slaves. He declared, "It is then quite clear that there is a citizenship of the United States and a citizenship of a state which are distinct from each other and which depend upon different characteristics or circumstances in the individual." Read that again. Distinct from each other, not my words, his. Now here's where it gets interesting. After the ruling, 3 other Supreme Court justices immediately stood up and said, "No!" Justice Stephen Field warned the decision had reduced one of the Constitution's greatest protections to a vain and idle enactment. Justice Noah Swain said it had turned what was meant for bread into a stone. Think about that. More than 140 years later, Justice Clarence Thomas wrote that the court's interpretation of the Privileges or Immunities Clause should be reconsidered. He questioned whether the slaughterhouse cases had been correctly decided, noting that the pool of scholars who agree it was wrongly decided is near 100%. In layman's terms, what the 14th Amendment was originally created and intended to do is not how it's commonly interpreted today. Think about what that means. The debate never ended. This one case touches almost everything in American jurisprudence today. Congress and the lower courts just stopped talking about it. Why? Because the answers are truly uncomfortable. So I started asking a different question. If the Supreme Court is still arguing about the 14th Amendment's application, openly stating it needs to be addressed, then what else have I been told was settled? That really isn't. If the Civil War settled the battlefield, the slaughterhouse cases helped shape the constitutional debate that followed. Now, the uncomfortable question: did this case single-handedly pave the way for agency and fiat currency, contrary to the Constitution, and allow the federal government in the District of Columbia to seemingly supersede the sovereign states? More importantly, how does this all relate to modern-day fiat money and debt? That question led me into agency and legal fiction doctrine, into lawful money versus legal tender, into suretyship, into negotiable instruments, and into the Uniform Commercial Codes, the actual legal case precedents set by the Supreme Court law of the land. And I noticed something. The deeper I read, the less certain I became about what I'd always assumed to be true. For instance, modern-day courts only use the term persons, same with insurance companies, and pretty much anything that carries liability. Even elevators don't use the word people. Next time you're in an elevator, look at the little plaque disclaimer, 15 persons, max weight. But you never see the word people. Why is that? You will not find the word persons in the Constitution. Only we the people. Two separate and distinct things, just like in the slaughterhouse cases. Persons instead of people or individuals. Most have no idea what those words actually mean in court. The definition of person might surprise you. This led me into a sort of identity crisis. I started asking myself, what type of person per the law am I truly, and what is my fiduciary relationship to it? Maybe that's the real lesson. Not that you should believe everything you read, but that you should never let someone else do all of your reading for you. And I noticed something. The deeper I read, the less certain I became about what I'd always assumed to be true.